Good morning and welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, I know we have a lot of new attendees and registrants, so thank you for being here today. And if you're new to, if you're coming back to see us again, thank you as always for your interest and support. So you as the attendee are currently in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address your questions. Your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions to us at any time. You also received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in a section marked Handouts and the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. For CFPs, CPAs, and many other professionals, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements, please email me your ID number, and for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we do ask that you please just take a couple minutes to fill out the simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve for planning needs that your family and you may have now or in the future. And we always look forward to being a resource to you here at Elville & Associates. So briefly, as we have a lot to cover, I'd like to offer you an overview of our firm and share just a little bit about Steve. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Steve Elville. We offer many different practice areas and services here at Elville & Associates, which include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location here in beautiful Columbia today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. We do offer a lot of education, and that is a focus of ours here at Elville & Associates. We do that in several ways, through our planning processes with our clients, through over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only 2 firms in the state of Maryland that has an accredited CCP, as we call it, accredited by the Client Care Academy in Boston. We also work with our clients with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, each year presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you'd like to learn more about our mission and what we do to make a musical difference in the lives of children each day, please reach out to me, and I'd be very happy to share our story with you offline. With all that said, we're going to start off with a brief poll to learn what's brought you to our webinar today. We want to get to know you. And that poll is to get to know our audience. Please tell us what has brought you to today's webinar. So I'm going to go ahead and launch that poll and make the choice that best suits your situation right now. And the choices are, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited, which is not unusual. Third, I'm a financial advisor here to learn to benefit my clients, which is always very good. And lastly, I'm an interested family member here to gather information. So whatever brings you here today, thank you for being part of our webinar series, and we look forward to sharing some information with you today. Take another couple seconds here. Okay, so we have 43% that say I need to set up planning for a loved one with special needs. 13% say I have planning in place, but it needs to be revisited. Another 17% say I'm a financial advisor here to learn to benefit my clients. And lastly, 25% say I'm an interested family member here to gather information. Okay, well, thank you for participating in that. That gives us an idea of who we have with us today. Steve, I'm going to go ahead and make you the presenter. So you should see that button pop up on your screen in just a moment.
Thank you, Jeff.
I see that.
And you should be able to see my desktop here as I start my slideshow.
Looks good.
All right, thank you, Jeff.
All right. It's all yours.
Appreciate that introduction, and good morning, everyone, and welcome to our workshop. This is one of our favorite workshops, Planning for a Loved One with Special Needs. It's a beautiful Wednesday morning. Thank you for spending your time and your valuable time with us this morning. Jeff is my longtime and dear colleague who really is essential and critical to his efforts are critical to help me bring this information throughout the years. So it's our privilege to be with you this morning and bring education to you about planning for special needs. And we are very privileged to be very involved in the special needs community all these years. So again, I thank you for being here. I want you to look at this workshop on this beautiful day as I'm looking out our window here in Columbia. I want you to think about this workshop as a maybe a master class, like a mini master class on planning for special needs. And I want you to know that I know intuitively, just from all of my experiences with special needs families and loved ones that have disabilities, that this subject matter is very near and dear to you and to the future of your loved one. And we take that very seriously. So I want you to know before we start that we're really going to be covering a lot of information. It's a little bit overwhelming, but I want you to use this literally this PowerPoint that Jeff has provided to you. I want you to use that as a tool. I want you to use it as a reference, because you're going to know after this workshop, you're going to know 95% more than anybody you know about planning for special needs. So what am I saying here? I'm saying that the information is available. It is here. The counseling is here. So if you're having any kind of anxiety about the planning situation or reviewing old planning that you may have put in place years ago, or if you haven't ever done special needs planning, just know that the information is here. It's going to be explained, and counseling is available in the future to help you walk step by step through this process. So again, I just wanted to make those brief introductory remarks and just say how privileged we are to be with you this morning. And with that said, we're going to get started. Thank you for being here. One other introductory remark is that Jeff is a real expert moderator. He's going to be taking your questions. He's going to know that many of you have questions. So I just want to encourage you to ask questions. Feel free to send questions to Jeff. We will be stopping occasionally throughout the presentation to take questions. And although we can't give legal advice over this webinar, we will be giving some general comments to your questions. And we want to be as helpful as we can and provide materials to you as well. All right, we'll get started. So why plan? Well, All planning is goal driven, or should be goal driven. When I say that, I mean GOAL, goal driven. You're going to have lots of reasons for planning for your loved one with special needs. Many of those reasons are very personal to you, what's going on in your life, what has gone on in your journey. And I know many of you have had various journeys. So we're really talking about is not only what is your goal, but we're talking about how to plan for a loved one with disabilities and enhancing their quality of life, protecting them, providing advocacy for them, providing for a long-term plan for them, many times and most times above and beyond the world of public benefits. And we don't want to restrict their potential. For example, there are new laws in place, such as the Supported Decision-Making Act, which I'm going to talk about before we get done today, that have expanded the potential and the rights of individuals with disabilities. But we're talking about your goals and the broader goals of special needs planning, which are to maximize the potential of our loved one and also protecting them. Some of these are your goals, providing financial security. We're going to talk about that. Understanding and leveraging public benefits. This is something that many of you are experiencing. Your loved one is getting SSI or Medicaid benefits, or they will be getting those benefits in the future. Sometimes we need to drill down more to understand the nuances of these benefits, and even more importantly, to make sure that the trustee of a special needs trust understands these things. We need to have a lifetime team, a management team. And if this is something that is new to you, we might call that an advisory team. You should have an elder law or special needs planning attorney to advise you, a certified public accountant, a CPA, a tax expert. Now, yes, these are professionals that cost money and it's not inexpensive, but in a perfect world, you would have the financial advisor that you need, even the life insurance specialist that you need. The advocate, we're going to talk about that, the advocate that you need as part of your team. Again, the attorney and the CPA. We're talking about putting a proper lifetime team in place. That could be a goal and should be. Planning for housing, planning for advocacy. Who is going to advocate for our loved one? Where will our loved one live? I know many of you are concerned about this issue. Should I leave real estate into a special needs trust if my loved one has the ability to be independent? Or will we be utilizing public housing or group housing situations? Coordinating for the entire family as gathering and congregating around the loved one with disabilities to make sure they're protected. Making sure legal protections are in place for our vulnerable special needs loved ones. And sometimes the assets that we are leaving for our loved one, we want to preserve those assets for others. God forbid if our loved one were to pass away sooner than we anticipated. So all of these are benefits and potential goals of planning. So some of the things I'm going to be talking about today, I'm going to intentionally say them more than once. I'm going to intentionally be redundant because it's just my way of teaching, and I'm hoping you see this as a kind of a classroom session here. And we're going to be talking about things that I will bring up for purposes of emphasizing what I want you to remember. So again, we want that right team of advisors to be in place. That's one of the first things I want you to start thinking about. Do you have a team right now? And if not, we will help you put one in place. Does your planning have flexibility? We are living in a very changing world, very fast changing world. Legal issues are changing, laws are changing. Public benefits could change, which we hope they don't. Sometimes in the past, it looked like they were going to change, but they didn't. The trustees can change. Your loved one's health or situation can change. We want to provide for lots of flexibility in the planning. Again, the advisory team, do we have that in place? Do we have advocates in place? Many of you have been advocating for your loved one for a long time. If you have an older adult child with disabilities, and many times it's a good idea to put advocates in place now during your lifetime. Trust protectors. Trust protectors are a new concept for many of you. We are big believers in the use of trust protectors, which have been officially recognized in Maryland since 2014. To make a long story short, we're going to talk about trust protectors a little bit later. Trust protectors are a way to provide flexibility for the trust or the supplemental needs trust that you put in place for your loved one, and to provide for all kinds of protections above and beyond the basic terms of the trust and above and beyond the trustee's duties. We'll talk about the trust protector. So we want to create an effective plan. So let's talk about that. Well, we want to have vision. We want to have imagination about what we want for our loved one's future. Now, that's hard to do for many of you, and I'm just going to be presumptuous here because of my experiences with thousands of special needs families, that you are very busy, and many of you are overwhelmed, no matter what your lifestyle is, what your job is. Many of you don't have a lot of time to think. This has been my experience. Many of you don't have time to form concepts about getting from one step to the next with planning. So we want to give you the time to think. I'm sitting in conference room 1 here at Elville and Associates. We have 3 conference rooms, and they're all equipped with high-tech equipment to really help us think through and experience the special time that we would spend in counseling to craft and think through issues to design the right estate plan and special needs plan. We want to give you time to think. We want to give you a time to think about where will your loved one live? What type of care is required? Many times we have to face the issue of whether a conservator or a guardian is needed. Hopefully not, but many times this is necessary and important, despite the fact that we have the new supported decision-making laws. Who else will be involved? What kind of team members will be involved? What are the challenges that we could face? We want to build layers of protection. We want to build layers of financial protection. We want to build layers of management oversight. And we want to understand the process, and we want to have a purpose. So a lot of these things are very high-level concepts, and some of them are more specific. But I want you to take away that last bullet point. We want to have a purpose, a goal, and we want to have a process. And that's what we do here at Elville and Associates. We try to bring a process to the table so that we can get from point A to point B. Now, one of the ways to have oversight, one of the ways to detail your preferences, one of the things that you can do to make your special needs plan very personal to you is to create a memorandum of intent. So one of the things that we want to make sure that you have access to is what we would call a special needs memorandum of intent. Jeff and I are happy to provide that to you, but let me give you a little bit of background on this. There are, as you can imagine, millions of trusts in place today of all kinds: charitable trusts, revocable trusts, life insurance trusts, special needs trusts. Most of these trusts are created on word processing programs or basically estate planning programs that create these things. Some of them are handcrafted, but many of them look the same. If I were to stack up thousands of estate planning documents or trusts in my conference room here, most of them, believe it or not, would look similar. So the way that you can make your particular supplemental needs trust or planning very, very personal to you and protect your loved one at the same time is to use this memorandum of intent. By using a memorandum of intent to tell the world, to tell the trustees, to tell anyone who is in contact with your loved one and has anything to do with the trust, to tell them about your loved one, what are their needs, what are their desires, what are their eccentricities, who are their doctors, who are the family members and support system. This memorandum of intent is possibly the most important thing in special needs planning, because it not only tells a future trustee about your child or loved one, but it also makes the trust very personal to you and lets you take your goals, your desires, and put them into a solid format. And the wonderful thing about a creative memorandum of intent is that you can update that every so often. You can update that every 3 to 5 years as your loved one gets older, and you can save that in a word processing program, and this can be a living document. So this is one of the things I want to emphasize today. The other considerations include looking at the financial aspect. How much money should we leave? How much money will our loved one need? What will be their, their needs in the future? Now, many of you don't have financial advisors, and many of you do. I would strongly recommend that you start thinking in terms of who is my financial advisor and how can my financial advisor work in coordination and collaboration with my special needs planning attorney. Financial advisors today, so many of them out there. If you don't have a financial advisor, I will be happy to refer you to some or several that you can interview. But these financial advisors, and this is the main point, these financial advisors want to help you. They have resources. They have special needs planning resources, many of them do. And especially those financial advisor friends of ours who are colleagues that are on this webinar this morning, they should be congratulated because they are increasing their knowledge. They want to learn how to serve families with special needs loved ones, and they have resources that can make projections and can make all kinds of recommendations for how much life insurance should we have. Remember, in a perfect world, all families with a loved one with special needs would fund a special needs trust today. We'll talk about this a little bit later. They would fund the special needs trust now with assets because none of us know how many assets we're really going to have when we pass away. So I encourage you to not only think in terms of the collaborative advisory team, but to think in terms of allowing yourself to take advantage of the resources of financial advisors, many of whom are dedicated to people who have the struggles and the challenges of a loved one with special needs. Now, this is an old-fashioned spreadsheet. Many of you could get something even more elaborate than this on the internet. But again, I'm just encouraging you in these slides to use the resources of your financial advisor and your collaborative team. Another issue, as we talked about earlier, as you consider the scope of a special needs plan, is how to plan for your loved one's incapacity. So in a perfect world, our loved one with special needs has a high functioning capacity. They are individuals that still, even though they are disabled in some way, they have mental capacity, and they could execute what? Healthcare directives, an advanced medical directive, or a financial power of attorney. And what would they do if, having done that, what did they accomplish? Well, they appointed agents. For example, they may have appointed you as their agent. Well, now, because they have a healthcare agent and they have a financial agent, they're avoiding guardianship. So whether you knew that or not, you now know that one of the major reasons to sign these advanced directives or powers of attorney, if the loved one has legal capacity, is to avoid guardianship of the person or guardianship of the property. Now, if our loved one does not have the mental capacity or ability to understand these documents, then they may be a candidate for guardianship. Guardianship is the highest form of intervention. So we do have to address this issue. And one of the key words that I would throw out to try to help you parents who are, tortured by this issue, we don't want our loved one to lose their rights in guardianship. We want them to be able to live the highest and best lifestyle and be able to be self-supporting. But sometimes it's difficult to really face the reality that our loved one may be vulnerable. And there's no one answer. This is a very fluid situation that has to be talked out in counseling, legal counseling. And that is about whether to pursue guardianship. So this is a big issue. It needs to be addressed as part of special needs planning. And we want to avoid guardianship if we can, of course, but we may not be able to if our loved one is truly vulnerable. And especially, of course, if they do not have mental or legal capacity. Now, a supported decision maker is a person who many of you may have heard of this concept by now. Maryland happily has passed a supported decision-making law, which is very broad, and it's made me very happy because those of us on the elder law side of the fence have been waiting for this for a long time. And in our newest newsletter, our latest newsletter, I've written a long article about supported decision making. And if you would like to get this newsletter and see that article, which is really the first article in the newsletter, I encourage you to read this, familiarize yourself with supported decision making. This is a game changer for the disability community. A supporting decision maker is not an agent under a power of attorney and is not a guardian. A supporting decision maker is a person who the person with disabilities has said, I want this person to help me make my decisions because I can make my own decisions to whatever extent possible, provided that I have someone that can help me do so. So the happy and good news is that the state of Maryland has decided that as a society, we want to help people with disabilities be able to reach their highest and best potential and to be able to make their own decisions to whatever extent possible. So that's a very, very good thing. It greatly expands the rights of self-determination for those with disabilities, although it may not be practical for everyone. And I was just speaking with a family yesterday. Supported decision making is not going to really be much of a tool for them based on the mental incapacity and condition of their loved one with disabilities. And it is a complex subject, but it is a very big step forward in the rights of those with disabilities in Maryland. And I encourage you to learn about it. The other thing I'm excited about is that supported decision making is a substitute for guardianship. So someone who is on the borderline there, but still has mental capacity or has some capacity to direct their own decisions and at least say whatever they want to have as their choice or their preferences, that person can have a supported decision maker no matter what their capacity level is, up to a practical limit. And they can also have a supported decision maker as part of guardianship. So Maryland says that if you're under guardianship, you can still have a supported decision maker. So it's a broad subject that we will have a whole webinar about in the future, and we have done one in the past. And we will be developing supported decision making agreements that are going to be necessary to put these in place. And I should say not necessarily that you have to have a written agreement, but I think as a highest and best approach, you would have a written agreement for a supported decision maker. Even though the law says it doesn't necessarily have to be in writing. So a broad subject, I just wanted to throw that out here that a supported decision maker can be part of guardianship, or guardianship can be avoided altogether through the use of supported decision making. So just one more wrap up on this subject. Under a financial power of attorney, we have agents. Under guardianship, we have guardians. And in the middle, so to speak, a way of thinking of it, is we have supported decision making as a potential substitute for guardianship or a part of guardianship. And a person with mental capacity back on this side of the fence could be a person who has a financial power of attorney and an advance directive, and they have agents under those documents to avoid guardianship. But that person with disabilities could also have a supported decision maker. If they go to the bank, if they go to the ballpark, wherever they go, they could have a person who they've designated as a supported decision maker to help them make their decisions to whatever extent that they possibly have to make those decisions. Jeff, I'm going to stop for just a second to see if there's any questions so far before we get into public benefits.
Well, thanks, Steve. Not many questions as of yet. Do have one that just came in, which I could probably actually answer. It's how do we get Mr. Elville's article on supported decision-making law? Briefly, that is actually on the front of our website right now, and I will be including that link to that article in my post-webinar follow-up email that I send out after every webinar, which you'll get this afternoon, or at the very latest first thing in the morning, but I'll try to get it out today. And that is the only question as of now. I'm sure they'll be coming though.
Thank you very much, Jeff, and thank you for that question. We're now going to get into understanding public benefits, which is not only important for you as parents and loved ones, but especially for trustees. So Let's try to get our minds around public benefits, and I'm going to give you some simple illustrations, and I'm hoping that this will make sense. We don't ever want to categorize people, but I would say loved ones with disabilities come in different varieties as far as the benefits that they are eligible for. So many of you are very familiar with SSI, Supplemental Security Income, uh, Social Security Disability here in the middle, and on the right-hand side, Section 8 housing. Now, we're not going to spend too much time on the right-hand side. We're going to focus on the left column and the middle column. Let's start with understanding means-tested benefits. Well, in this country, ever since 40 or 50 years ago, means-tested means you can't have more than $2,000 in your name if you're a person with disabilities. You have to have less than $2,000 if you're going to qualify for waiver benefits, SSI benefits, and any other means-tested public benefits as a general rule of thumb. So the person who turns 18, even though there are some people who receive SSI in impoverished households, most of the time it's someone who has attained 18 and they are disabled. This is the definitive definition of disability, someone who is approved or eligible for SSI. As a result, many of you know, this person obtains Medicaid, or what we call medical assistance benefits in Maryland. In California, it's called Medi-Cal, but Maryland, we call it medical assistance. And now this person has health insurance and other benefits under Medicaid and SSI. So this is a means-tested benefit. Now, we're going to see slides on this a little bit later, but many special needs families are not aware that at the time they retire, if their child is a disabled adult child, this child is a child who was disabled prior to age 22, then the child will transition from SSI to Social Security disability benefits, not on the child's work record per se, but on the work record of the parent, because the child is a disabled adult child having been disabled prior to age 22. And when their parent retires, the child will get 50% of the amount of that parent's Social Security. So that child will transition from SSI and Medicaid to Social Security disability. And now look at this slide, and Medicare, and for many children, Medicaid. So the person who transitions from the left column to the middle column is going to do so either on their own work record or on the work record of their parents, because they are a disabled adult child, and they will receive not only Medicaid, especially if they're on means-tested programs, but they will also receive Medicare. So this is something to understand, and we're going to see on a further slide that at the parent's death, the child will then receive 75% of the amount based on the fact that they were disabled adult children if they were disabled prior to age 22. So it's very important to start trying to get your mind around these two columns on the left. Some special needs loved ones disabled loved ones live in HUD housing. And I want to just address that real quickly. HUD housing is very difficult in the sense that with a supplemental needs trust, which we're going to talk about in a few minutes, a trustee making distributions for the benefit of a beneficiary who lives in HUD housing, that trustee is going to have a little bit of a touchy situation because that HUD housing is very income sensitive. And so what's going to happen is HUD will look at benefits that are distributed from a special needs trust as creating income that's attributable to the person who lives in the housing, the disabled person, and that can cause issues with rent going up. So there are ways to get around that through using ABLE accounts, which we'll talk about. But the point of this whole slide here is to start getting the gist of SSI and SSDI and what is the interplay between those two things and how children transition if they are disabled adult children. They're transitioning from SSI to SSDI at the retirement of a parent or the death of a parent. Now, I'm not going to spend a lot of time. These are more resource materials. I'm not going to spend a lot of time on the qualifications of SSI. This is something that you can read and benefit from. Disability has its own definitions here. You're going to be able to see what these definitions are. The SSI resource test, as I mentioned, is still $2,000, $3,000 for a couple. I actually had seen several couples, especially an elderly couple I once knew, that was eligible for SSI, both of them, even though they were not disabled necessarily in the sense of cognitive disabilities. Now, with SSI, this is another source of confusion. The SSI beneficiary can own a home. Now, it may not be the best idea that they own a home, and it may be just downright nonsensical that they own a home, but they can own a home, and that home will not disqualify them from SSI. They can also own an automobile, and that may or may not make any sense, but an automobile is not counted, and certain other items are not counted. So the SSI beneficiary typically cannot have more than $2,000 in their name, and certain assets are exempt, although many of these assets would not be owned by them outright most of the time. And the current SSI benefit in 2022 is $841 a month. In California and places like that, there are supplements. It's important for you and it's important for trustees to understand that SSI has earned and unearned income concepts. And what we don't want is we don't want our loved one with disabilities to either earn so much money, either on an earned income basis or unearned income basis, that it reduces their SSI to zero and then they lose their medical assistance. So these concepts are very important. One of those concepts is called in-kind support and maintenance. So many of you on this call understand this because you have a loved one with disabilities living at home with you, and when they were living with you, they are receiving food and shelter. And we know, as whether we agree with it or not, we know that SSI is for food and shelter. So if you are providing food and shelter for your loved one, you are obviously providing them with something that SSI was intended to pay for. So you may have experienced that the SSI of the loved one will be reduced by 1/3. And so this is called the presumed maximum value rule. The most that they can reduce that is by 1/3, but we don't want to lose that 1/3. So many of you will have a child who is paying rent to you under a rental agreement, and that will avoid typically the loss of the 1/3. So that's just something to conceptually get our minds around. Why am I emphasizing this to you when I know so many of you parents are knowledgeable about this to some degree and have experienced it? Well, the main concern is that trustees need to understand this information. So many trustees don't, and that's a dangerous thing because we don't want a trustee to distribute assets in such a way that it would cause the beneficiary to lose their means tested benefits. So we want to make sure our trustees do several things. We want to make sure they understand the concepts of public benefits, and I would recommend a book, and Jeff can send out this information if you don't have anything to write it down on, which is How to Administer the California Special Needs Trust. Now, this is a book by Kevin Urbash of the Academy of Special Needs Planners, who happens to live in San Francisco, I understand. So please try to ignore the word California for those of you who live in Maryland on the East Coast. It's a wonderful book, and it explains all these concepts that I'm talking to you about today, and you can get that on Amazon. And Kevin is a great author. I strongly recommend that book or other books. The trustee needs to read the book. The trustee needs to read the trust. We want to make sure that if we're naming a trustee, that trustee is going to read the trust. Surprisingly, many trustees do not. Social Security disability, we're not going to go through the tests and so forth, but notice that the person who is on Social Security disability with disabilities is going to receive Medicare after 24 or 25 months. This is the concept here of the disabled adult child. This person was disabled prior to age 22, and now this can be a very powerful thing, and it can make many parents happy to know that their child will receive these enhanced benefits of income in the future above and beyond SSI when the child transfers away from SSI. So this is a very important concept. If you've never heard of it, which I know most of you, many of you have not, remember that your child who was disabled prior to 22 will be considered a disabled adult child. Medicaid and Medicare cover certain things. In the interest of time, and I know many of you want me to talk about the special needs trust concepts, we're just going to kind of leave this with you as supplemental material that you can read and learn from and get a great sense of. Again, Section 8, we have to deal with Section 8 housing or HUD housing in a certain way. There is actually great Section 8 or HUD housing in certain places in Maryland. It's not always a bad thing. And if our loved one needs to take advantage of that, we can deal with that in many ways. We know housing, again, is one of the biggest issues that many of you are facing, and we want you to have some peace of mind about planning for housing, okay? A special needs trust can pay for housing. A special needs trust can own a house, and we're going to learn about that. When we purchase a house, again, we're going to make this judgment call about how that house should be owned and whether it passes from you to the special needs trust or whether the trustee in the future can buy a house within the special needs trust. Jeff, I'm going to stop just for a minute to see if there's any other set of questions before moving into special needs trusts.
Thanks, Steve. We do have some questions here. And I'll start with the top one here. The first one is, in the written agreement, should you name a single supported decision maker or can multiple people be named?
That's a great question. I will say, as we get started here, the new law takes effect on October 1st, and we're going to have to see how things kind of play out. I think my recollection is that the law is so broad that it does not have to be just one person. It can be many or more than one person.
Thank you. Next question, if parents are divorced, which of the parents does the child get Social Security from?
That is a great question, and I'm going to say that is going to be fact specific. And my best answer, and I'd have to research that, is that it would be the Social Security amount of the parent with the highest benefit, or the person who had retired first.
Okay. And as a follow-up to that, will the child move to SSDI upon the first parent's retirement or not until the second parent retires too?
That's a great question. Subject to looking at the facts there, my experience has been the first parent is all that's needed.
Let me read through this. Let me just another one or two here. Let me just read through this next one here. SSI told me that my wife and I, each having a single vehicle, each disqualifies us due to having too many assets. Any thoughts on that?
Yeah, I don't know enough facts about that question. When are you saying that you yourself are on SSI or a child is on SSI and has more than one vehicle? So maybe you could respond to Jeff at our next break, and we could clarify that just a little bit.
Okay, thank you. Lastly, if you could please repeat the title of the California book, and I'll also note that I will send out a link to that book in my post webinar email to everybody.
Thank you. That book is called How to Administer the California Special Needs Trust by Kevin Urbash.
Okay, and one more?
Yeah, go ahead.
No, I'm sorry, go ahead, Steve.
Urbatzch.
Okay, and last one, will money as gifts be counted against SSI?
Yes, so what I'm going to read into that question is, if a person that is getting SSI receives money and then gifts it, yes, there is a penalty period that person would suffer whereby they would be disqualified from SSI, if I heard or read into your question correctly.
Okay, thank you, Steve, and thank you for the questions, everybody.
Thank you. All right, as we look at trusts, we want to get our terminology correct, and don't worry about it if you don't use the correct terminology. We're going to get from point A to point B, I promise. So the third-party trust, this is the trust that we call a third-party supplemental needs trust. As you look across from left to right on this graph, this is the trust that most of you are going to be interested in as you look at special needs planning as part of your own estate planning. This is the trust that you can leave assets to your loved one with disabilities with no payback to the state of Maryland. It can be very broadly construed and designed, and it is the bread and butter of special needs planning. So we call this a third-party supplemental needs trust. And we're going to talk about the two types of these trusts. One is the type that you can put right inside of your own will or right inside of your own revocable trust, if you have a revocable living trust as your basic estate planning document. And what this third-party trust means is that the money is being left from a third party. Let's say you're a parent or a grandparent or a sibling. You're leaving money for your loved one with special needs, and it's coming from you directly to the third party trust. Notice I said it's going directly to the trust. It's not going to the loved one. And that is why the loved one is never deemed to have received the money. The money is for their benefit, but they have never really received it. So therefore, it does not disqualify them from benefits or anything that they're eligible for, and it protects them. So the third-party supplemental needs trust, you'll notice here it says the source of funds is from anyone else other than the beneficiary. The person who can establish is anyone except the beneficiary, so it's usually a parent or grandparent or other loved one. And upon the death of the loved one with disabilities, God forbid, the money can go wherever you say it goes. So there's no payback to the state of Maryland. This is the beauty of the third-party trust. But the next two columns, or the horizontal columns, are what we call first-party trusts. These are trusts where your loved one with disabilities has received funds that they should not have received. They received funds because they were injured in some terrible accident or birth injury or a train accident. Many of you have heard about these kinds of trusts. We call these D4A trusts. These are trusts that are established under the U.S. Code 42 U.S.C. 1396P D4A. Yes, that's a mouthful, but that is where these trusts come from in the federal code. And states like Maryland have sanctioned or codified these trusts under the Maryland law. And so therefore, these two trusts, the D4A and the D4C, which is a pooled trust, and it has its own purposes. These trusts are for people who have received funds that disqualify them from Medicaid benefits and public benefits, and those funds need to be diverted into a different kind of trust, and we call this a special needs trust. So the third-party trust we call a supplemental needs trust, and these other two trusts we call those special needs trusts. But it's okay if you use the word special needs trust for all of these trusts as a general term. It's okay. Now, a D4A trust is something we do a lot at Elville and Associates, and that trust can be established by a parent or grandparent or a court or a guardian. And notice, it also could be established by the disabled person themselves. That is under a new law at the end of the Obama administration called the Special Needs Fairness Act that said a high functioning person who has disabilities, they can establish their own first party trust. The challenge with these trusts is that at the death of the beneficiary, there has to be a payback to the state of Maryland. So whatever the state of Maryland has paid for this person, that person has received an accounting, and at their death, that has to be paid back. So that's a payback trust. And many of you are not going to be concerned about this so much, but others are concerned about it. And if we had our preference, we would plan to avoid the first party trust. But many times the first party trust is needed. For example, if you are a military veteran and you want to assign your military pension to your loved one, we have to use a first party trust, a D4A trust. So third party trust is the bread and butter of estate planning for special needs. The first party trusts are special trusts that we use when we have to, because strategically we have to get money out of the disabled person's name and keep them eligible for benefits or another purpose. So again, this is the best method of doing estate planning for the average family with a loved one with special needs. We call it a third party trust because It is the assets of someone else coming into that trust, and it never actually is owned by the person with disabilities. We see these as great alternatives to these problems. Now, many people who do not do what you're doing this morning, they haven't educated themselves. They don't try to get legal advice. Some people try to self-help themselves, and we don't want to do that. And here's why. An outright inheritance, well, what would that do? It would disqualify our loved one. They would have to use a first party trust. The money would have to be paid back to the state of Maryland if there's any money left. That's just not a good way of going because it causes issues. Some people, and I see many of these trusts, some people with at no fault of their own have gotten involved with an attorney or a law firm that does not understand special needs, and the wrong type of trust is actually created. Now, that is not to scare you this morning. That's just to tell you the reality that we do see a lot of trusts that are improperly drafted. And what happens is if money is left to that trust, even if it's from a third party, that trust can cause the disqualification of our loved ones. So we don't want that. And we want to fix problems like that if they exist. Some people say, well, I'm not going to provide any inheritance to my loved one. I'm just going to leave it to someone else. Well, that can be very problematic. So let's say we left money to sisters or brothers or other loved ones that we're just keeping money out of the name of the loved one. Well, that money could be lost under any variety of circumstances. First of all, the person we left the money to could have creditors, hopefully not. What if they die after they receive these assets and they didn't think through planning and they've left those assets to someone else other than your loved one, and now there's no legal connection between the loved one and the money that was left supposedly for them? What if that person was getting divorced and they lose half the money in a divorce, or if they have tax liens against them and they lose the money to Uncle Sam, or we decide if we are the sibling or the loved one, we decide we don't want to take care of the loved one. We've had a change in our lives or a long-term care issue. So these other self-help methods we just want to strongly caution against to not go that direction. Now remember, the third-party trust, again, as we continue to emphasize this, the beneficiary themselves didn't create the trust. The trust does not own the beneficiary's money. The trust owns money that someone else left for the benefit of the beneficiary. This could be from a will or a trust. It could be from an IRA. It could be from a life insurance policy. So the third-party trust is very flexible, and the beneficiary has the discretion in the trust. And the way the trust is written, it protects the beneficiary from public agencies being able to say, hey, that is the beneficiary's money, they are disqualified. No, that would not happen because of the way these trusts are written. There are no paybacks, and it can be revocable during the life of the grantor. So when I was a young lawyer, we always drafted these trusts as irrevocable trusts, but the modern trend is to draft them as revocable trusts so that there's no extra tax reporting. And of course, we build in lots and lots of flexibility into the trust. Now, in the interest of time, I'm going to keep moving because we've been pretty thorough in taking our time through this presentation. We have to be very careful about one of the biggest issues in estate planning today, not just special needs planning, and that is who the trustee is going to be. Is this going to be a family member? Is it going to be a professional? Is it going to be our attorney? Is it going to be a CPA? We want to really understand this because this is one of the major counseling issues that we need to do in our conference room with clients. We have an entire webinar on how to choose a trustee. So Jeff would be happy to send that to you if you would like to see that. So what do we want in a trustee? Well, we want someone who understands public benefits and can manage the money, and that person is very trustworthy, because we don't want to have to post a bond. Bonds are very expensive and they would deplete the trust assets. We want to understand relationships, and would this person be entitled to fees? Yes, they would be entitled to be paid. Are there any conflicts? What is their knowledge and experience? And this is one of the big ones that I have found over the years. Is this person actually willing to serve? And what is their ability to serve? Now, no matter who we choose as trustees, we've talked about a little bit earlier of the trust protector. I want to talk a little bit about the trust protector here just to give you background on it and the trust advisory committee. But let's start with the trust protector. Maryland has recognized trust protectors since 2014. We believe trust protectors are absolutely essential, although not required. They are essential to give the trust flexibility. So what would a trust protector do? And this is shocking for some of you, so I recognize that. The trust protector would have the power to remove and replace trustees. Let's say the trustees that you provided in your doc provided for, they are either not willing to serve, or when they were serving, they decided they didn't want to serve anymore, or they are having a health issue and they really shouldn't be serving, but they refuse to serve. A trust protector can be very, very critical to making sure the beneficiary is not affected by this and the trustees would continue. A trust protector can have the power, usually has the power, I should say, to amend the trust and make sure that it keeps up with changes in the laws or any modifications that is needed. So those are the two major powers of a trust protector: power to remove and replace trustees, power to be able to amend the trust for changing circumstances. And then usually we add other powers, such as power to review an accounting and just powers of general flexibility, because we're living in a changing world. And if you think about it, trust can last forever. Trust can last throughout the entire lifetime of the beneficiary, and that is a long time. So we want to have flexibility. A trust advisory committee is an optional provision that we recommend. And basically, in a nutshell, this says that if my trustee needs guidance, if my trustee needs help and does not know the answers to certain things, well, these are key issues. They certainly can hire professionals, but what they can also do is convene a committee. They have the authority to say, well, I need to call in the service coordinator. I need to call in the advocate. I need to call in the psychiatrist or the MD, other MD. These are flexibility provisions that we think make most parents happy, in the sense that they have built in lots of contingency provisions for changing circumstances. Now, that's a lot of information. I'm now going to show you visually what the modern special needs trust looks like. And this is just my way of looking at it. I want you to think about the special needs trust, and I'm going to use the correct terminology here. Whether you're using a special needs trust of the first party type, or the bread and butter trust, which is what we call the third party supplemental needs trust, these concepts are generally the same. We want to take a lot of care and thought about trustees. We want to think in terms of who our trust protectors are. I know that's a lot to think about, but that's what we're here for, is to talk you through those issues and find solutions. A good supplemental needs trust will have Maryland ABLE provisions. We don't have time to really talk much about ABLE today. Many of you are aware of ABLE. We want the trust to be able to fund an ABLE account. We want the trust to have advocate provisions, not because the trustee couldn't do that himself or herself already, but because we want to remind the trustee that they have this ability. We want the trustee to be aware. We want them to see these provisions and to think, oh, I've got these powers. I better consider them. We talked about the memorandum of intent. We want to make sure that you've completed that. That's a key provision. It's a lot of work. I apologize, but it does make your trust customized for you and your loved one. We talked about the trust advisory committee, but we also want to talk about special retirement plan provisions. So I'm just going to take a second here, and I know this is a lot of information. Don't worry if you don't retain all of it. Those of you who have retirement plans, which probably are most of you, you may be aware of something called the Secure Act, all caps SECURE, the Secure Act, which was signed in 2019 by President Trump, and it became law in 2020. The Secure Act is a very broad bill. It's really good for most Americans as far as saving for retirement. But unfortunately, what the Secure Act did is it hit people hard who are leaving IRAs and 401ks to loved ones who are not disabled. So loved ones who are not disabled which is not what we're talking about this morning, those loved ones have 10 years to take retirement plan assets out of IRAs. 10 years is not very long, and Uncle Sam is hitting people hard for income taxation on IRAs, unless it's a Roth. Well, the good news is your loved one with special needs or your loved one with a chronic illness is exempt. They are exempt under the Secure Act, which means that they can stretch out. They can defer the taxation of IRAs, just like we used to be able to do prior to 2020 for all beneficiaries. So your loved one with disabilities, your loved one with chronic illness, and their special needs trust, their supplemental needs trust, both are exempt. But with the supplemental needs trust, we have to make sure that even though the loved one is exempt under the Secure Act, that the trust itself meets the requirements of the IRS so that it too is exempt. So these are special planning considerations. As we continue to talk a little bit in a redundant way about trustee duties, remember, and Jeff found these folks. These are people who have all this knowledge, and this is what you want to shoot for. This is what you want to do when you're naming trustees. Your loved one with disabilities is going to need advocacy. We want the trustee to understand that. We want the trustee to have their best interests in mind, to communicate with them as much as possible and as much as reasonable, promote their life and their independence, and understand public benefits, because if they don't, they're going to potentially hurt the loved one with the wrong type of distributions. We want them to understand finances. And here's a key. They themselves don't have to have all the knowledge of the financial world, but they need to understand that they have the right to do what? Hire professionals. They have the right to engage professionals. That way, they can protect themselves as trustees, hire professionals to do the investing, and that is the proper way. Hire professionals to prepare the taxes, hire professionals such as attorneys to advise, and to keep accurate records, and again, to keep the beneficiary informed. So we want our trustee to look at these concentric circles and really say, yes, that's the ideal trustee. Now, we may not be able to find that person who's ideal, but we want to be as close to these qualities as possible. Now, a supplemental needs trust or special needs trust can pay for certain things, and this can affect their government benefits, the person who is the beneficiary. Jeff has a handout that he would be glad to send to any of you who are interested about what a special needs trust can pay for. And that's, remember, the special needs trust is the D4A type typically, and that special needs trust can pay for a lot of different things, but it's not as broad as a supplemental needs trust. But for those of you who want to start getting your minds around what a special needs trust can pay for, Jeff has that handout that he can give you. Now, many parents, again, we're getting back to the issue of the advisory team now. How much should I fund into a trust? Well, do I have a financial advisor who can help me do projections, Monte Carlo analyses, those kinds of projections that will show how much money we will have likely in older age? Do we need life insurance as a tool? When we are using our retirement assets to fund the trust, how much retirement assets will we have when we get older? So again, I encourage you to start thinking about these issues. It's a lot to think about: advocacy, taxes, how much money are we going to have to leave? I want you to start thinking about that on a broad basis, because the truth is none of us know how much money exactly we're going to have in the future, and this is going to give us the key to whether we need to fund the trust now or really fund the trust later at our deaths. And the truth is, most people fund the trust later at death, but in a perfect world, we would all fund the trust immediately when we establish the trust. We talked about the first party trust as being the type of trust that will allow a person to continue their eligibility for public benefits. And as I mentioned, the first party trust is usually from a personal injury award or a birth injury. Many of you have experienced this kind of thing, or someone many times receives an inheritance. A good example is a case I saw several years ago where a well-meaning person, loved one, left a person 15 years old on the autism waiver, left them a $250,000 IRA. So this is the kind of thing where the D4A trust or the first party trust can be used to preserve benefits. Those of you who are reading carefully will see on this slide that even if you don't have a loved one who has received money directly, many times using a first party trust or getting one established, because it doesn't cost very much to get one established through the Attorney General's office, who has to approve it after they receive the trust from us. Many times, even though the loved one does not have assets in their own name per se, that's going to disqualify them, it's a good idea to have both the third party trust and the first party trust in place, just in case someone leaves money inadvertently to the loved one. And now that first party trust is in place and can be implemented immediately. So Jeff, I'm going to just stop there for a second. We're getting towards maybe the last 10 or 12 minutes of the presentation. I'll let you decide whether we should take questions or whether I should forge ahead. Okay, Jeff might be having a little bit of technical difficulty there, so I'm just going to continue.
I'm
Hey,
sorry,
Jeff.
Steve. Yeah, I apologize. I was on mute. My apologies. Do have a couple questions. I think it'd be okay to go through them if that's okay.
Sounds good.
First question is, thanks for all the great information, Stephen and team. Our special needs disabled son is 17 now, and we want to get started with your team for guardianship and SSI. We have the checklist and have contacted relevant folks, physician, etc. Can you let me know the steps to get started? First meeting, what all to get, overall process, what to expect. Any thoughts on that, Steve?
Thank you. Yes, thank you for that. If you have the checklist, you are way ahead of the ball game. And I would just say, do the best, because that checklist is 2 or 3 pages. Just go ahead and put in that basic information and drop off to us, or we will send you a secure link to be able to send that to us. And then we will start drafting a petition for guardianship. And then the next step would be to come in and review it. So I would just start with that checklist, and then Jeff or Mary Gay Kramer will reach out to you to set an appointment to come in and actually look at the petition for guardianship. And I think that would be the first step. Thank you so much.
Okay, thank you. That's all the questions for now. And
All right.
Praveen, I'll reach out to you later.
All right, thank you. And now, as we get toward the latter part of the presentation, what is the process of establishing a trust and the financial considerations? Well, looking at this kind of swirling clockwise rotation here, what we're attempting to do here is show that we have tried to break this special needs planning process into something that you can visually see, where we start the process by meeting, and then we go through a series of educational steps. So Elville and Associates, we feel that we are the thought leaders in Maryland on legal education for clients. And so what this is a representation of how we try to educate clients. And you'll notice there in the middle, we're talking about the advisory team, and that could include also an insurance professional or an advocate. So just a visual representation of our process. We believe in a process because of all the things going on in your lives, the confusing nature of the world today and the pace of change. We want to take our time to think through this process so that you can establish a plan that you can work through and maintain in the future. We talked about guardianship and conservatorship. That's part of the process of seeing whether that's needed, in addition to understanding public benefits, in addition to establishing a special needs trust or supplemental needs trust. Whether or not, now, thank goodness, we have the supported decision-making laws, whether or not this is something that is going to be a good answer for our loved one. So these are all considerations. Remember, if we do entertain guardianship, just like this nice person just said, it's going to be a guardianship of the person or a guardianship of the property or estate or both. So this is the highest form of intervention. We have to decide as a group, as a team, whether or not that is the right approach. And many times it is a necessity, and we want to counsel through that process. Here is a reiteration of what I was mentioning earlier, this triumph for persons with disabilities. Please read my article, not because I wrote it, but because This is a culmination of so much effort on people's part, like Megan Rusiano and others. So now this is a wonderful thing that is so broad. Many of us are shocked at how broad it is, and the potentialities are fantastic for people with disabilities. Basically, people with disabilities are now deemed, whether the public realizes this or not is going to be another thing that may take years. People with disabilities are now deemed to be individuals who have the right to take risks, and not be just protected from risk all the time. The idea being that if they have the right to take risks, that they have the right to be free in a broad sense. So this is going to be good, and it's also going to be very scary for many people, like parents who have been protecting loved ones for years. Just take it as a theoretical beginning. I remember last summer or spring, I was giving a workshop for the Brain Injury Association, and I'm sorry, it was at their annual convention, and we had many people with disabilities in the presentation about supported decision making. And after I had gone through all the questions and answers and had gone through all the presentation, a person in the audience who was actually a person with disabilities, he had the last word on everything. And when he was given the microphone to say what his final comments were, he said, "It's a good start." And I think that's the way that it should be looked at. The supported decision-making law is a very good start, and we all need to educate ourselves about it and become aware of what its true intentions are. So this is a couple of slides here on supported decision making. We won't have time to necessarily go through all of them, but again, it can be formalized or not formalized. I highly recommend that it be formalized. It can be an alternative to adult guardianship. It is part of what I just described as a paradigm shift. It's a new world of self-determination for the disabled. And I'll let you read that and also hopefully read my article. So as we start to wrap up, we want you to be proud of yourself, that you're educating yourself. We want you to create a memorandum of intent. That's a big job. It's easy for me to say. You're very busy, but I think it's a project that's really, really worthwhile for you, and we can give you a template. We want you to establish your own estate plan if you don't have one, a will or a trust plan for yourself, a revocable trust, powers of attorney, advance directives. If you have an existing plan, we want to just update that and review it. We generally do not charge to review documents, so please feel free to send us your existing estate plans and we'll review them and we'll give you recommendations on them. We want you to establish a special needs or supplemental needs trust, whether that trust is embedded inside of the will or inside of the revocable trust that you have, or whether that trust stands on its own. We call that a standalone supplemental needs trust, and it can be done either way. In counseling sessions, we can tell you what the pros and cons are of having the trust in or out of the trust. It will protect the beneficiary no matter what, but there are certain practical considerations. We want to name the supplemental needs trust as beneficiary of retirement plan assets generally, if that's your goal and that's your desire. We also want to financially calculate our needs and project our needs and work with financial advisors. We want to begin to understand public benefits but maybe even more importantly, ensure that our trustees are educated. Elville and Associates is one of the only law firms I'm aware of that actually conducts family meetings. So part of our education outreach is to not only educate you, but to educate your trustees or other family members. So we welcome you to bring them to meetings if you would like. And also at the end of the planning, we always try to make sure that we do a family meeting so that others that you have named as your fiduciaries, your trusted advisors, that they understand the planning. We want you to be thinking about these plans for the future, like housing, who will be the advocate, and all of those things that I know you're worried about. And we want you to just understand that the special needs plan needs to be part of your overall and can be part of your overall estate plan. So as we wrap up, we want to give you a path forward. We're known for education, but we don't want to just educate. We want to make sure that we give you a way to move forward with that education and take advantage of it. So we invite you to have a no-cost consultation. Again, we're here to educate. We have electronic technology. We have everything here to try to educate you. Please come and feel relaxed. There's nothing to fear. It is very strange to come and talk to someone and share personal information when you're not used to doing that on a day-to-day basis. But we want you to complete a questionnaire. This is a little bit of work. It tells us about you. The basis of all good special needs planning and the basis of all estate planning is really in that questionnaire. So we use a pretty comprehensive questionnaire. Again, we want you to come, bring your estate planning documents with you if you have existing documents. Most people, just because of life's busyness and the things we have to attend to, most of us don't keep our estate plans updated. We want to encourage you to bring those existing documents so we can review them. We want to help you form an advisory team. This may be something that you didn't need in the past. It could be something that you need now. So I have been privileged to train many financial advisors and work with CPAs, and we can help you establish that if you would like. We want you to come with questions. We want you to, if you're the kind of person that likes to write out questions or type up questions, please bring those questions. It makes our meeting very productive. And if you don't have questions, we are going to be just fine, and we'll talk to you and create questions in your mind to think about. And that leads us to one of the final things, which is we want you to come and have a goal. We want you to understand what your goals are. Some people are so overwhelmed by information that they need a little bit of counseling so that they can formulate what their goals are. So I want to strongly encourage you that if you don't know exactly what your goals are or what they should be, in the time that we would have together in the process of thinking, in the quiet space that we have to think in, we would help you attain or determine what your goals are. So Jeff, I'm going to wrap up. I'm going to thank everyone for your time and attention here. I hope you enjoyed the beautiful day, but remember, we are here to help you. We are here to help you move forward with review, learning, getting started, all of those things. Thank you for your time and attention. Jeff, I'll turn it over to you.
Well, thank you, Steve, for a great presentation as always. This is one that I never get tired of listening to. A lot of great information and something that we're very passionate about here at Elville and Associates. So, and I know we have a lot of people that this information is very important to on our webinar here today. So, and that shows in the many questions that we have here. So we're going to jump into a few questions here, if that's okay, Steve. And
Sounds good.
We'll close out here with a couple closing comments from me as well. So the first question, so a special needs trust, first party trust can be established after inheritance, correct?
That's a wonderful question. Yes. So many times we get calls from a service coordinator or a social worker or a parent who says, my child has just received an inheritance that they shouldn't have received because it's knocked them off of benefits and so forth. So yes, we get jump in, we create that trust either because the beneficiary has the ability to create it, or the parent or a court or a guardian, and then we get that approved as soon as possible and then move the money in there and we're back on track again.
Okay. Next question, I'm going to read it as it says, why guardianship instead of supported decision-making team as allowed by new Maryland law?
Great question.
Is guardianship a requirement of a special needs trust?
Great question. So guardianship is not required for a special needs trust or a supplemental needs trust, so to speak. Lots of people have supplemental needs trusts that are not under guardianship. They are not wards under a guardianship. And because the supported decision-making law is a little bit hard, the concept is very simple, but the broader idea is a little bit hard to just accept. So I'll try to describe it to you. So let's start with the definition, in my definition, I should say. Supported decision-making is about allowing a person with disabilities to make their own decisions to whatever extent possible, provided that they have the support to do so. Okay. Now, if we think about that, a person with disabilities could have the mental capacity to sign powers of attorney and advance directives. And if they did, what would they be saying basically? They would be saying, I can make my own decisions because I'm a high functioning person with disabilities. But if I can't make my own decisions someday because I'm disabled, then I've named agents who can make my actually act for me. They're not making my decisions, but they're acting for me because I can't do it myself. Now, under guardianship, if we go to the other extreme, a person who's under guardianship, typically under the old paradigm, that person does not have the right to get married. They don't have the right to hire a lawyer. They don't have the right to do anything without the court's approval. So that person has lost their legal rights unless the court has allowed them to vote under the guardianship order and so forth. So these are two opposite extremes. Now, in the middle is supported decision making. So supported decision making says that whether I have the capacity to sign powers of attorney, and let's say I do, well, I can still have a supported decision maker because that person does not make my decisions. That person helps me make my own decisions. They support me in making my own decisions. I can still make my own decisions. This person is just a supporter. So it's an accommodation. Whereas if I've lost my if I've lost my capacity, mental capacity, now I'm relying on my agent under a power of attorney. So a person can have powers of attorney and advance directives if they have the capacity, and they can also have a supported decision-making agreement. Now, conversely, let's say a person does not have mental capacity, so to speak, and they are vulnerable and they need a guardianship. Well, the new law says that if we go this direction, the person under guardianship could still have a supported decision maker. They haven't lost all of their legal rights like they would have in the past. They still have some right, if they have the capacity, to be able to say, yes, I want a supported decision maker, even though I'm under guardianship. And the net result of that is it expands the person's right of self-determination in a much greater way. The other thing that I'll just throw in here as we're starting to wrap up is that supported decision making, now being a part of the law as of October 1st, will require courts to say, not just in concept, but will require courts to say, really, truly, is there any other lesser restrictive alternative to guardianship? Meaning the court will have to consider supported decision making prior to a guardianship. So in the past, there was just a lot of leapfrogging from this side to guardianship. And now that supported decision making will have to be considered by a court as a real tool for the legal community and a protection for the person.
Okay, thank you, Steve. We have a number of people asking for the memorandum of intent. I'll be sending that out in my follow-up message to everybody. Melissa from the Homewood Center here in Howard County asking for us to present to their parents there. Melissa, I will gladly reach out to you. Thank you for thinking of us. We'd be privileged to do that. It's always, again, a privilege to come out and present in the communities that we serve. I'll be in touch with you about that right away. So thank you very much for thinking of us. And where do we find the questionnaire or other forms prior to the initial meeting? Thank you very much. I can send you those forms. That'll also, I guess I can add that to my long list here. I'll include that on my follow-up message as well. How far are you scheduling out for initial meetings? Steve, would you like to answer that, or would you like me to answer that question?
That's a great question. So, you know, as we are fortunate to be blessed in the special needs community and helping people, we do get busy. But I've always said as our policy here at Elville and Associates, if you have an urgent need or if you feel you know, that you would like to be seen sooner than later, we always make special accommodations. So my assistant Mary Gay Kramer and Jeff will collaborate with me, and we will make special arrangements if you feel that you would like to be seen sooner than later, or if the time that we arrange is not suitable, we will try to move things up, and usually we can always do that.
Very good. So, okay, I think those are all the questions, and we're just a few minutes before 11:30, so right on time. So I have a lot of things to follow up with you on, and just to summarize very briefly, the video link from today's presentation, the slides again, the link to the questionnaire, the document reflecting the uses of special needs trusts, also a link to several pertinent webinars, how to choose a trustee, guardianship, and the alternatives, information from Maryland Able's webinar, which I'll send out along with our friend Kelly Nelson, who's the Maryland Able outreach coordinator. I'll give you her contact information. Also, the slides after our presentation are Maryland Able's slides as well, which Kelly has very kindly allowed us to share with you. We don't have time for those today, but I'll also send you the Maryland Able webinar that we offered a little bit earlier this year. The supported decision-making article link I'll send to you, as well as the link to the How to Administer the California Special Needs Trust by Kevin Urbash. And lastly, as we wrap up, next week is a busy one for the webinar series we have here. We have our installment 11 of our wellness series, Staying Mentally Sharp, on next Tuesday. On Wednesday, knowing the difference between assisted living facilities and skilled nursing facilities. And then on Friday, we have Steve coming back to talk about understanding estate and trust administration. So a busy day here today and a busy day next week for us here. And we appreciate you being here as part of our Elville webinar series. Please reach out to us if we can be a resource to you in any way, or to schedule a time to meet with Steve. It'd be a privilege to serve you and be a resource to your family and you. So thank you for being part of our webinar series today, and we look forward to seeing you again soon. Have a wonderful day.
Thank you.